So people ask me, how do we do an enforcement investigation? Well, it's like any good detective story or puzzle. We gather and try to piece together the evidence to build a picture of what's happened, when's it happened, or is it still happening, and who's been involved in the failures that we found. We can't take enforcement action against anything a company does. The specific obligations that we can enforce are set out in legislation or in company's licence. As part of our investigation, we have to go through a process of understanding exactly which obligations have been breached, and why we think they've been breached with reference to specific legislation, previous cases or guidance that we've issued, or what we think a reasonable company would do in fulfilling those obligations. Ofwat has a duty to enforce those obligations we're responsible for enforcing, but if we think the breach is small or we're suitably satisfied that a company's taken steps to address it, we can decide not to take action. Where that's not the case and we have serious concerns, we open a full investigation to decide what steps we should take. There's a number of different possible outcomes from an enforcement investigation. We can impose a financial penalty on the company of up to 10% of its annual turnover, or we could impose an enforcement order that sets out a series of actions that the company needs to take to bring itself back into compliance with the obligation it's breaching. We can also accept undertakings from the company where they commit to take forward those actions to bring themselves back into compliance. We're also making greater use of settlement, where if a company can satisfy us that it's no longer breaching that obligation and is providing suitable redress for customers, we can accept a package from them. It's often a quicker and more effective solution for customers, and we can often secure extra measures that we wouldn't otherwise be able to through a fine or an enforcement order. In taking our decision on which of those outcomes we want to take forward from our investigation, we consider what's the best outcome for customers. But we also consider what deterrence effect our decision has for the company itself to ensure it doesn't make the same mistakes again, but also for the wider sector. When we decide to impose a financial penalty, there's a range of different considerations we take into account in establishing the level of that financial penalty. We also use that as a benchmark when considering a settlement package put forward by the company. The kinds of things that we consider are the seriousness and the duration of the breaches that we found, the degree to which customers, other companies in the sector, the environment or a regulatory regime have been affected by the failures, whether the failures are repeated failure by the company. We also consider the degree to which the companies cooperated with our investigation, including whether it came forward to tell us about the failings in the first place, and the degree to which they may have covered up or been open about the information they're sharing with us. And of course, we also consider the steps the company's taken to address the failing and to provide redress to its customers. You can find out more about our approach to enforcement and how we establish the level of financial penalties on the guidance on our website.